Good afternoon, all. This application hearing is in the matter of CFI 092-2021 before His Excellency Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants have failed to appear, and the defendants are represented by BSA Ahmed bin Hazim and Associates. Lead counsel is Mr. Martin Koshtel. Thank you, Your Honor.
Thank you very much. Yes, Mr. Koshtel, you can take it that I've read your skeleton argument, and I've read a lot of the underlying documents, but not every page, obviously. How do you want to go about this? Do you need, presumably, if I'm in your favor, you need a reasoned decision?
Yes.
Albeit it can be fairly short.
Yes, that's right.
Yes. Well, how do you want to go about it? I mean, as I see it, your claim is simply based upon the attempts in France and in Massachusetts to enforce the worldwide freezing order granted in the DIFC.
Yes.
Initially, the first order was sought to be enforced in France, and then after the second order was made, there were further proceedings in France and in Massachusetts.
That's right.
And you've produced evidence in the form of, are they both affidavits from lawyers in Massachusetts and in France?
They are.
Explaining the work they've done, the amount of their fees charged, the lack of any substantive recovery of fees in the jurisdiction of France and Massachusetts.
Correct.
And therefore, and coming down to those figures that you claim for in the in your skeleton argument and in the summons. Do you want to tell me anything else?
I think. Can I just say, first of all, I'm suffering from a cough, so if I cough intermittently, then I apologize in advance. Secondly, the pagination of the bundle is out by 7 pages because of the new system.
I realize that.
Yes.
It's because of a new system, is it?
That's right. There's a new system where an index is generated after the bundle is submitted, but the index is not available when the pagination takes place, initially as a draft. Yeah. So whatever page number I put down was based on the draft.
That's 7, yeah.
Yeah. So going back to the substantive issues, so what your lordship has summarized is in essence the claim, and there's really not much more to say, save that perhaps what I would invite your lordship to do is to give some consideration in the reasoning, perhaps to what Mr. Nouri Al Saleh has submitted, as you may have seen in my skeleton argument from paragraphs 28 until 37
give me a moment. 28 to 37.
Yes.
What in particular do you want to bring to my attention?
So just so that your lordship is aware, the second claimant did respond to one of the attempts to serve him in Kuwait, where he suggested that there isn't any jurisdiction for the DIFC courts to award damages pursuant to the undertaking, for the simple reason that because there wasn't any jurisdiction in the first place for the worldwide freezing order, there isn't any subsequent jurisdiction for this court to grant damages. Now, obviously, that's not our position. Yeah. And because your lordship has already granted the inquiry, this is a redundant point, but it might be, maybe as a matter of obiter in your reasoning, it might be worth including something on jurisdiction in these sorts of circumstances, because one can see that this argument may arise again. I don't know, by
The short answer to it is surely that in obtaining the freezing order, Mr. Nouri Al Saleh gave an undertaking to the court, and that gives the court jurisdiction to enforce that undertaking.
Yes. Now he might. I accept that this discussion is somewhat moot, but it could be argued that that undertaking is between the court and him, and therefore jurisdiction can only be established under the gateways available. But I would say that the undertaking given between him and the court falls as a matter of jurisdiction under the DIFC regulations gateway, which I've already set out in the skeleton argument.
Oh, I see.
So I appreciate that it's a technical exercise somewhat, but it is a substantive exercise in another sense to establish with some authority that this court has jurisdiction in circumstances where the underlying WFO has been discharged for want of jurisdiction.
Yes. The oddity, of course, is that the appeal court decision in this case was wrong.
Yes, well, only to an extent.
There was jurisdiction.
Well, only to,
but
yes.
it would have but we would have set aside the order anyway on the merits.
Yeah, and that's another answer anyway to the jurisdiction point.
Yeah.
But I would go further and say that under the rules specifically 25.25 for anyone listening later, and Article 26 of Law Number 2 of 2025, which is the Dubai law.
Can you give me those again?
Yes. So if I take to paragraph 33 of my skeleton argument, it will assist your lordship. So under Rule 25.25, that stipulates that an undertaking may be given by will be required by the applicant to the court to pay any damages which the respondent sustains and which the court considers the applicant should pay.
Yeah.
Now that is an undertaking that is required by the court pursuant to this rule.
Yeah.
That rule is not.
Therefore, that brings it within which gateway?
Yeah. So if your lordship needs to see the actual law, that is that.
I have the law somewhere in paper.
Okay.
Tell me where it is. Tell me where it is, just in case.
Yeah, it is at page. Sorry, I'm just waiting for the bundle.
1024.
I have to wait for the new. I have to check the new pagination. Sorry, it's actually at page 990.
Oh.
No, sorry, I said 990 because I'm referring to the traditional gateway. It's actually, yes. Let's go to 990 first, and then I can work your lordship through it.
Hold on a sec. Yeah.
So Article 14 of the Dubai Law Number 2 of 2025.
It just ties in with your skeleton. Oh, yes, here we are. Paragraph 36 of your skeleton.
Yes, exactly. Then I tie it in there. Exactly. And that is at page 991 in terms of Article 14A(7).
Yeah.
All right. So the RDCs of regulation 25.25 is the gateway under the rules. Of course, relying on Nest Investments and your lordship and your brother judge's decision in Sandra Holdings cumulatively confers jurisdiction on this court via the undertaking. Otherwise, it would be an absurdity if a litigant can then say, well, you didn't have jurisdiction anyway, if we're talking about jurisdiction.
Yeah.
So I think that deals with that, and I would invite your lordship perhaps to say something about that if necessary, although I accept it may be persuasive rather than binding on any other court. Your lordship has already summarised the position scope of damages. The only, perhaps, I don't know if your lordship needs to hear from me on exemplary damages.
Yes, I do.
Yes.
You'll need to persuade me on that.
All right.
Before we do that, can you help me on one thing? I have a recollection. It might be said, it might be argued at least, that you can't get as damages legal fees which are irrecoverable in the jurisdiction where they are obtained. In other words, if Massachusetts doesn't allow you to get your legal costs, why should this court bypass that rule of Massachusetts procedure? And I have a recollection of an appeal court case that I was in, Sir Peter Gross was in, and the Chief Justice Zaki was in, where we said something about this in connection with some fees in Cyprus, court fees, and we said we saw no reason why they shouldn't be recoverable under the undertaking and damages, I think it was. If you're able to find that for me, I tried to find it yesterday and I couldn't.
I have to confess, I've tried to find any judgment globally on this point, and I wasn't able to find any. But I'll have another look. Certainly,
if you find anything in the next day or so, if you could let the court officer know.
Yes.
And but I think it was to do with fees in Cyprus.
Okay. All right. I'll have a look. Does your lordship have any? I appreciate your lordship hasn't been a member of this court for many years, for a number of years, but not. So I think we're looking back maybe to in the last few years, by the sounds of it.
In the last, I think I would guess it's about 3 years ago.
All right, I'll have a look.
Or 3 or 4 years ago, and as I say, I was sitting with the Chief Justice and with Sir Peter Gross.
Okay. All right, I will have a look, but I would have submitted in any event that when an undertaking is given, then it is an undertaking that it will pay losses arising from the WFO. And as I've set out with the authorities, and in particular Smith against Day and Abbey Forwarding, the way losses are quantified is rather discretionary, beyond the simple rules of contract. And whilst it may be a good starting point to look at the principles of contract, like remoteness of damage mitigation, etc., the court is not confined to those principles. They are to be applied by analogy. And in this particular,
I think Mr. Justice Mayle said something.
Yes, exactly. But one step further is that pursuant to the undertaking, and I can take your lordship to the undertaking itself, because I would say that there is a particular section of the worldwide freezing order which should put this point to rest at the very least. If your lordship looks at page 958 of the bundle,
Yeah.
So Justice Sir Jeremy Cook granted permission to the claimants to enforce the worldwide freezing order amongst other places in France and the United States of America, which means that there is contemplation that there will be fees incurred, legal fees incurred, and perhaps even court fees, but fees incurred by the defendants in having to potentially defend themselves, potentially, and I put it no higher than that, at the point at which this worldwide freezing order was granted, meaning that whatever comes with it is potentially at large to be covered by the scope of the undertaking. So if that is within the reasonable contemplation of the claimants, then it's a very difficult position for them to sustain that any legal fees should not be recovered simply because the courts or the system in place in France and the United States doesn't allow for recovery of fees. But as it happens in France, there was a recovery of 9,000 euros, for which credit has already been given. So I will, in any event, have a look for that authority. But those would be my submissions on the facts of this case in any event.
Yeah, thank you.
Now, going on to...
You want to tell me about exemplary damages?
Yes. So I accept that there isn't any definitive authority covering exemplary damages, but there are 2 cases where exemplary damages are mentioned. And the first is the Smith and Day case, which is the 19th century case,
Yes, give me a second. Where in your skeleton do you deal with this? I can't remember.
I'm sorry, paragraph 68.
68. Yep.
Yep. But because the pagination is wrong, I'm going to, if your lordship just bears with me, I'll take you to the authority.
I can add 7 to any number that you want me to.
Yes, of course. So 1064.
Yeah.
Excuse me. It begins, your lordship will see the reference to the rules as to damages are shown in Hadley and Baxendale. And then it says, if the injunction had been obtained fraudulently or maliciously, the court, I think, would act by analogy to the rule in the case of fraudulent or malicious breach of contract and not confine itself to proximate damages, but give exemplary damages. And now, as it happens in that case, there wasn't any fraud or malice, but I accept that this comment is perhaps obiter as well, but that's the first reference to exemplary damages. Now,
Yeah.
can I deal with this authority in the context of Abbey forwarding, which should be on page 1158.
Yeah.
And bearing in mind that Abbey forwarding is an authority which looked at the entire spectrum of cases that related to inquiry as to damages. So it is a good authority because it took the opportunity to look and analyze the entire history of the matter. Now, paragraph 36 of the decision by Lord Justice McComb, he quotes from the judgment of Lord Justice Brett, as we just looked at. And he goes over to page to deal with other matters. Now, he says at paragraph 37, page 1159, he analyzes the reasons why an inquiry as to damages was declined because of the alleged damage being too remote. But he didn't go on to deal with exemplary damages. So whilst he may have quoted from it, he didn't say, for example, or he didn't hold or decide that exemplary damages are not recoverable, nor necessarily that they are recoverable. Essentially, he was silent on the point. So I bring that to your lordship's attention because, of course, whilst it may be an authority that quotes from Smith and Day, he doesn't then go on to deal with it in any definitive matter. And the final piece of authority that I would like to turn your lordship's attention to is the extract from G on commercial injunctions, page 1248 of the bundle.
Yeah.
It begins with the paragraph at 11-049 saying the following. It has been said that the court can award exemplary damages, and there are 2 cases cited, Smith and Day being one of them. I tried to find the other one, Le Laboratoire Servier. However, that citation was incorrect, so I wasn't able to find that judgment. But it may just be an incorrect citation or an incorrect judgment, but I couldn't find that specific case. Anyway, however, when the wording of the undertaking obliges the claimant to pay damages only in respect of losses suffered by reason of the order or carrying out the order, and that is a point that segues back into the legal fees, perhaps. It is restricted to damages awarded to compensate the defendant for those losses. In principle, the court could award aggravated damages when the effect of making and implementing the order has been made more severe for the defendant by the high-handedness or misconduct of the claimant or his agents, but only as compensation to the defendant. Now, what I will accept... What does that mean? Yeah, so what I think it's saying is, if there is a particularly egregious way in requiring compliance by the defendant in adhering to the terms of the order, then there can be an award of aggravated damages. So I accept that might be,
but only as compensation.
well, yes, only as compensation.
So in which case, why aren't they simply damages?
Well, perhaps, but I think maybe it can't be damages because what this relates to is the conduct of the claimant and the difficult position being that the defendant is being put in potentially by, depends on the facts. I'd have to think of a certain set of facts, but I think that this is what it's getting at. But what I was going to go on to say is this: that I accept the distinction in our present case is that the defendants just didn't comply with the orders. So I accept that. But what I would say that Lord Justice Brett had in mind was something wider, not necessarily complying with the order, but perhaps to put a marker down and to, or very simply, just make the point, if the claimant acts in a particularly egregious way, then compensation may be awarded to the defendant to compensate for any particular hardship or wrong misstep or just reflecting the fact that the way that the claimant went about enforcing the order was egregious. So what I would say in our case is the Kuwaiti proceedings, the first Kuwaiti proceedings, were the reason for was the reason for the WFO being initially granted. That WFO was then taken to France. The fact of France enforcing the WFO was a reason cited for the continuation of the WFO in the DIFC, as well as the first Kuwaiti proceedings. The fact that in France there was an attempted enforcement of the WFO shouldn't be in reality a reason for the continuation of the WFO, because that was reliant on the WFO in being granted in the first place. And if the WFO was set aside for any reason, then vis-a-vis France would have to set aside in any event for that reason alone. So what we're talking about is this: the first Kuwaiti proceedings were the only operative proceedings on which the WFO was granted. And as I sought to set out in my skeleton argument, and as recorded by the facts of the Court of Appeal, and evidence is given about this on this point by, I think it was Mr. Binder. By the La Liberté. The first Kuwaiti proceedings ultimately were dismissed in February of 2022, before which point that the claimants took the WFO to the Massachusetts. So the underlying...
Say it again.
Yeah, the first Kuwaiti proceedings were dismissed by February 2022.
Yeah.
Before the claimants took the WFO to Massachusetts for enforcement. So whilst the WFO was in existence, the fact remains that the underlying proceedings in support of the worldwide freezing order granted in 2021 had been dismissed by February of 2022. Not just that, there was no appeal to the first Kuwaiti proceedings. There was never an indication given that the first Kuwaiti proceedings were going to be appealed. So that those sets of proceedings were concluded February 2022. Even if we were to give them the 30-day time allowance for appealing, which I understand is the position in Kuwait, that will still just take us to March, but certainly not beyond that, well into 2023, when the WFO was still being enforced in France and Massachusetts. And even when the WFOs were eventually set aside in Massachusetts and France, the claimants appealed those decisions, and they were still continuing with the attempted enforcement of the worldwide freezing order.
Well, I can see that you have a complaint about that conduct, and whatever label you want to attach to it, egregious or whatever. But where does it get you? Because if your damages claim at the moment gets you full compensation for the lawyers' fees in Massachusetts and France. What else do you legitimately want?
What I'm inviting your lordship to consider, and I accept, as I think I've already accepted, is that there isn't any definitive authority on this, and I equally accept that your lordship would be breaking new ground, perhaps. But if there is an acceptance that the conduct was particularly egregious, then there may be an award of compensation beyond the damages that, beyond the special losses that would arise from the enforcement of the WFO in America and in France. So it would be akin to a personal injury compensation, but not quite the same.
But it's still compensation.
Yeah, it's still compensation.
So you need,
and it's still damages.
It is intended as recovery of damage you suffered.
Yeah.
But I still don't see. Going back to G, for example, I'm not sure whether he's using exemplary damages in the same sense as aggravated damages. I thought they were different. But he ends up, but only as compensation.
Yes, he does.
So I don't understand that passage at all. There seems to be saying you can get exemplary damages as long as they're not exemplary damages.
Well, he then goes on at 1150 at the bottom of that particular page to talk about general damages. And then he does at one other point refer back to exemplary damages. I think that was maybe at the end of 2 paragraphs up or 1 paragraph up. So G appears to be using terms perhaps interchangeably. Quite what that means is it could be moot, and maybe he's talking about the same thing. But what I suspect G on injunctions is getting at is there can be an additional award of damages over and above special losses. I think that's what he's saying. And I think he's saying that based on the authority of Smith and Day opening that gateway. Although, as I've said, we don't have an authority which definitively says, yes, you can certainly get exemplary stroke, aggravated stroke, general damages all being one and the same thing. But there is certainly authority about general damages in page 1249 of the bundle. Again, the extract from G goes on to deal with that.
So what you're really asking, I'm just wondering if what you're really asking for is not exemplary damages so much as general damages.
Yeah, I mean, it might well be better framed as general damages, and I accept that what we claimed for was exemplary damages. But I suppose what I'm saying is that the case law which introduces this concept seems to refer to exemplary damages, and G goes on to, well, use many forms of expression, but ultimately it may just be the same thing. Anyway, but the submission I make is primarily based on their conduct, which I've already gone through, and that being not I accept it doesn't neatly fall into the fraudulent or malicious obtaining of the injunction, which is what Lord Justice Brett had initially had in mind. But what I would say is that, and particularly reading on from the extract from G, is that there is and given the wide discretion afforded to the court in these matters anyway, there is still a gateway to award damages over and above special losses. Of course, if your lordship is not with me, then your lordship will then perhaps just go on to award special losses, which we've already dealt with. So exemplary damages would be an addition. It's not to cover the special losses, although not specifically, but I accept that there is an argument that the facts that we have pleaded in support of exemplary damages might well, if in case your lordship had any doubt to grant the losses anyway, it may have assisted in that respect as well. So in that sense, there's a dual purpose. So
just to be clear,
yes,
in paragraph 72, you cite certain aspects of the defendant's conduct, the claimant's conduct in justifying the grant of exemplary damages. Those are all, none of those add to the list of factors to be covered by general damages? Do they simply go to the conduct rather than any specific
Yeah, they go to the
injury?
conduct. Yes, that's right. Yes, that's right.
Yeah. Okay.
All right.
That's helpful. Thank you.
Yes. Those are the substantive submissions. Assuming your lordship is with me at the very least on granting the 500, I've got to get the figures again. But the losses were 46,071 euros and 96 cents and $574,401.25.
Yeah.
Then if your lordship grants those, then I would go on to deal with costs.
Yes.
Now, in terms of costs,
I've seen your two cost schedules.
yes. All right. Can I just make one point of clarification in respect of the second statement of costs, which is, actually 2 points of clarification, but I'll wait for your lordship.
Hang on. I've just nearly lost you off the screen.
Yes. Okay.
That's better. Found you again. Right.
Okay.
Second statement of costs.
Yes, there's just two corrections to make. Firstly, in relation to the hearing, we erroneously put down 3 hours. It should have been 2 hours because I think the listing ultimately was for 2 hours today.
Yeah,
so that needs adjustment. And secondly, on disbursement.
Where do I find that?
Oh, it should be just above the statement of truth. So maybe the second page of the PDF if you've got it separately. It's the very last table.
Oh, 3 hours there. Yeah.
Yes, so that needs adjusting. And on disbursements and expenses, I don't know why it for some reason it doesn't provide the explanatory notes, but it's just for your lordship to know. There was a heavy application fee, which was $2,000.
Sorry, where am I looking?
Just underneath attendances at the hearing, there is expenses and disbursements.
Yeah.
It's currently listed as 22,621.95.
Yeah.
Fills. Just to explain, that at the moment covers a heavy application fee for the claim for damages and service of this application. And if your lordship remembers, there was the claim for damages was filed under a non-application form, if I can put it that way. It was under the other e-filing form, and then we were directed to serve it by file it by an application form notice. So this covers that. And I was told yesterday, quite late, that there are some further costs incurred in Kuwait because the fees that you see there under disbursements only cover the Cayman, and that would be Sandra Holdings. But Mr. Nouri was served personally in Kuwait. If your lordship just bears with me for a moment, I need to convert Kuwaiti dinar to dirhams. But we need to add essentially 1,000 Kuwaiti dinar. So if you want to just bear with me. So that's 12,000 dirhams. That needs to be added. Now, those are the only corrections to make.
So that is adding it to the expenses disbursements.
Yeah. Yes, that's right. 12,000 to be added,
and reducing
and reduce
the attendances at hearing by a third.
Yes, that's right. Yes, that's right. Because the claimant is not present, the claimants, sorry, are not present. Nobody's here, of course, to go through this in terms of making any criticisms. But I don't know if your lordship has any particular questions or anything for me to explain.
No, this hasn't been served on the claimants, has it?
Let me just double check whether it was served by email at all. It may not have been. No, because we filed it yesterday. No, it hasn't been served on the claimants. So to be fair,
But the claimants, they are aware of this hearing, are they?
yes, they're aware of the hearing and they were aware of the previous hearing.
Yeah. Okay.
And
Right,
they haven't been in contact at all, since Trials and Hamlins came off record. I can't remember when that was, but that was a long time ago. That was around December, January. Other than the response that we went through about jurisdiction.
Yeah. Well, no, I'm not going to apply any particular expertise to the schedule of costs because I don't have that expertise, and there's no one here to take me through it. So it is what it is.
Yes.
Right. Well, thank you very much. What I'll do is I think I better do a written judgment dealing with the various points, albeit not necessarily at great length.
Yes.
And I'll let you have that as soon as possible.
Thank you very much. I presume your lordship will just apply the broad brush principles for costs in the usual way.
Meaning?
Oh, sorry. Maybe I misunderstood what your lordship was saying. When your lordship says it is what it is, did your lordship mean the figures are what they are, or the print? Oh, I'm a bit sorry. I misunderstood.
The figures are what they are, and I think I'll go through it again myself, but yeah. I can't imagine I'm going to apply any special knowledge of costs to it.
Sorry. Now I'm with you on it. Okay.
And there's no desperate rush. Is there in a sense if I got it out to you next week?
Is your not to put your lordship on the spot, but am I right in assuming that your lordship is going to grant the claim as pleaded, and your lordship is going to consider anything else that I've submitted today? So at the very least, can we inform our clients whether they're at least going to be granted the figures that we've been through?
Well, you can tell on an informal basis that the claim will be successful, at least to the extent of the Massachusetts and French fees.
Exactly.
And so I'm going to consider further the question of exemplary or aggravated damages.
Yes, that was exactly my question. Thank you.
But that's not for public consumption until the judgment comes out.
Oh, of course. Usual embargo applies.
Yes. There we are. Well, thank you very much, and thank you for your helpful skeleton. There's nothing else you want to raise?
Can I just look over my shoulder? Sorry.
Yeah, of course. Yeah.
Nope, that's everything. Thank you very much.
Well, thank you very much.
Thank you.
Earlier, I'll send something as soon as I can.
Great. Thank you, Your Honor.
Thank you.